Okay, good morning everyone. I am J. Mark D. Bukog from BS Criminology 3 Delta. For the continuation of our activity 8D, this is activity 8E. Okay, let's continue. Presumption of incapacity of committing crime is absolute. Number 3, a person over 15 years of age and under 18 unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provision of the Article 80 of this code. When such minor is adjudged to be criminally responsible, the court, in conformity with the provisions of this and the preceding paragraph, shall commit him to the care of custody of his family, who shall be charged with his surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in said Article 80. Number 4, any person who, while performing a lawful act, while with due care, causes an injury by a mere accident without fault or intention of causing it. Accident damnum absque injuria. Basis lack of negligence and intent. Elements. Number 1, a person is performing a lawful act. Number 2, exercise of due care. Number 3, he causes injury to another by mere accident. Number 4, without fault intention of causing it. Okay, let's go to under Article 12, Paragraph 4. The offender is exempt from not only from criminal but also from civil liability. This paragraph embodies the Latin maxim, damnum absque injuria. Accident happens outside the way of one's will, and although it comes about some act of will, lies beyond the bounds of humanly foreseeable consequences. If the consequences are plainly foreseeable, it will be a case of negligence. Number 5, any person who acts under the compulsion of an irresponsible force. Um, irres- irres- Irresistible force basis, complete absence of freedom, and element of voluntariness. Page 42, elements. That the compulsion is by means of physical force. Number 2, the physical force must be irresistible. Number 3, that the physical force must come from a third person. Force to be irresistible must produce such an effect on an individual that, despite of his resistance, it reduces him to a mere instrument and such incapable of committing a crime. It compels his member to act and his mind to obey. It it must act upon him from the outside, and by a third person he must act not only without a will but also against his will. Bakoli, who was accused but not a member of a band which murdered some American school teachers and has seen and compelled by the leaders of the band to bury the bodies, was not criminally liable as accessory for concealing the body of the crime. Bakoli act under the compulsion of irresistible force. Irresistible force can never consist in an impulse or passion or obfuscation. It must consist of an extraneous force coming from a third person. Number 6, any person who acts under the impulse of uncontrollable fear of unequal or greater injury. Uncontrollable fear basis, complete absence of freedom. Elements. That the threat which causes the fear is an evil greater than or at least equal to that which he is required to commit. Number 2, that it promises an evil of such gravity and imminence that the ordinary man would have uh, succumbed to it. Juris, to be a valid defense would be based on real, imminent, or reasonable fear for forum's life or limb. It should not be inspired by speculative, fanciful, or remote fear. The fear must be grave, actual, serious, and of such kind of that majority of men would succumb to such moral compulsion. The latter must be such as live a reasonable fear for one's life or limb and not speculative, fanciful, or remote fear. Threat of future injury is not enough. The compulsion must leave no opportunity to the accused for escape or self-defense and equal combat. Juries is the use of violence of physical force, an act done by me against my will is not an act. Number 7, any person who fails to perform an act required by law when prevented by some lawful or insuperable cause. Lawful or insuperable cause basis acts without intent, the third condition of voluntariness and intentional felony elements. Number 1, that an act is required by law to be done. Number 2, that a person fails to perform such act. Number 3, that his failure to perform such act was due to some lawful or insuperable cause. Example of lawful cause, a priest cannot be compelled to reveal what was confessed to him. Number B, to available transportation, officers not liable for arbitrary detention. C, mother who was overcome by severe dizziness and extreme debility, leaving child to die, not liable for infanticide. And 10th, proposes the exercise of freedom and the use of intelligence. Distinction between justifying and exempting circumstances. Number 1, exempting. There is a crime but there is no criminal. Act is not justified but the actor is not criminally liable. General rule. There is a civil liability. Page 44, number 2, justifying. Person does not transgress the law, does not commit any crime because there is nothing unlawful in the act as well as the intention of the actor. Absolutory causes are those where the act committed is a crime but for some reasons of public policy and sentiment, there is no penalty imposed. Exempting and justifying circumstances are absolutory cause. Other examples of absolutory cause: number 1, Article 6, spontaneous as desistant. Number 2, Article 20, accessories exempt from criminal liability. Number 3, Article 19, Paragraph 1, profiting oneself or assisting offenders to profit by the effects of crime. Mitigating circumstances. Definition: those circumstances which reduce the penalty of the crime. Chapter 3. Excuse. Chapter 3. Chapter 3, circumstances which mitigate criminal liability. Article 13, mitigating circumstances. The following are mitigating circumstances. Number 1, those mentioned in the preceding chapter when all the requisites necessary to justify or to exempt from criminal liability and the respective cases are not attendant. Number 2, that the offender is under 18 years of age or over 70 years. In the case of minor, he shall be proceed against in accordance with the provision of Article 80. Number 3, that the offender had no intention to commit a grave wrong as that committed. Number 4, that sufficient provocation of threat on the part of the offended party immediately precedes the act. Number 5, that the act was committed in the immediate vindication of grave offense to the one committing the felony, deleto, his spouse, descendants, or relative by affinity within the same degrees. Number 6, that of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. Number 7, that the offender had voluntarily surrendered himself to a person in authority or his agents or that he had voluntarily confessed his guilt before the court prior to presentation of evidence for the prosecution. Number 8, that the offender is deaf and dumb, blind, or otherwise suffering some physical defect, which thus restricts his means of action, defense, or communication with his fellow beings. Number 9, such illness of the offender as would diminish the exercise of the willpower of the offender without, however, depriving him of the consciousness of his acts. Number 10, and finally, any other circumstances of a similar nature and analogous to those above mentioned. Number 1, mitigating circumstances and incomplete self-defense. Number letter A, self-defense, defense of relative, defense of a stranger. Unlawful aggression must be present for Article 13 to be applicable. Other two elements not necessary if two requisites are present, considered a privilege mitigating circumstances. To have an incomplete self-defense, the offended party must be guilty of unlawful aggression. Without this, there can be no incomplete self-defense, defense of relative, or defense of stranger. When can the offender be given the benefit of ordinary mitigating circumstances? 1. If only the element of unlawful aggression is present. The other requisites being absent, the offender shall be given only the definite of an ordinary mitigating circumstances. Number 2. In cases of state of necessity, paragraph 4, avoidance of greater evil or injury. If any of the last two requisites is absent, there is only an ordinary mitigating circumstances. Lacking elements of exempting circumstances, mitigating over 15 and under 18. Over 15 and under 18, if minor, acted with discernment, considered privilege mitigating. Example, 14 years old stole a chicken with discernment as shown by the manner in which the act was committed. Causing injury by mere accident, if second requisites due care, and first paragraph of fourth requisites without fault, thus negligence, excuse me, only are absent, considered as mitigating because the penalty is lower than that provided for intentional felony. Uncontrollable fear, only one requisites present, considered mitigating. That offender is under 18 years of age or over 70 years in the case of minor. He shall be proceeded against in accordance with the provision of Article 192 of Presidential Decree 603 as amended by Republic Act 9344, applicable to A. Offender over 15 under 18 who acted with discernment. B. Offender over 15 under 18. C. Offender over 70 years old. Age of the accused, which should be determined as his age at the date of commission of crime, not date of trial. Various ages and their legal effects. Number 1, under 15 years, 15 or exactly 15 years old. Exempted circumstances. Number 2, over 15, below 18, exempted, exempt if acted with discernment. Number 3, minor delinquent under 18, sentence may be suspended. Presidential Decree 603. Number 4, under 18, privileged mitigating circumstances. Number 5, 18 and above, full criminally liable responsibility. 70. Number 6, 70 and above, mitigating circumstances, no imposition of death penalty, execution of death sentence, if already imposed, is suspended and commute. Number 3, that the offender had no intention to commit a grave wrong as that committed, can be used only when the facts prove to show that there is a notable and evident disproportion between means employed to execute the criminal act in its consequences Intent is an indispensable element of crime. When the intent is less than the actual act committed, a mitigated responsibility be imposed upon the offender. Not applicable when offender employed brute force. Not applicable to felonies by negligence and crimes against persons. If victim does not die, the absence of the intent to kill reduces the felony to mere physical injuries. It is not considered as mitigating only when the victim dies. Praeter intentionem means offender had no intention to commit so grave a wrong as that committed. Number 4, that the sufficient provocation or threat on the part of the offended party immediately precede act A. Provocation must be sufficient. B. Provocation by the deceased is the first stage of fight is not mitigating circumstance who had fled because from the moment he fled showing that he did not give any provocation for accused to pursue and attack him. C. Provocation must be immediate to the act. D. Threat should not be offensive and positively strong because if it was, the threat to inflict real injury is an unlawful aggression which may give rise to self-defense and thus no longer a mitigating circumstance. 5. That the act was committed in the immediate vindication of grave offense to the one committing the felony delito. His spouse, descendants, legitimate or natural or adopted brother or sister or relatives by affinity within the same degree. This has reference to the honor of the person that concerns the good names and reputations of the individual. Provocation made, number 1, made directly only to the person committing the felony. Number 2, cause that brought about the provocation need not to be grave offense. Number 3, necessary that the provocation of threat immediately precede the act, no time interval. Vindication, number 1, grave offense may be also against the offender relatives mentioned by the law. Number 2, offended party must have done a grave offense to the offender or his relatives. Number 3, may be proximate time interval allowed. Vindication of a grave offense. The word immediate here is an erroneous Spanish translation because the Spanish word is proxima and not immediatementa. Therefore, it is enough that the offender committed the crime with grave offense done to him, his spouse, his ascendants or descendants, or to his brother or sister, whether natural, adopted, or legitimate, and that is proximate cause of the commission of the crime. The court must consider the lasting effect and influence of grave offense to the offender when he resorted to commit the crime to vindicate such grave offense. Number 6, that of being acted upon impulse so powerful as naturally to have produced passion or obfuscation. Number 7, that the offender had voluntarily surrendered himself to a person authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of evidence for the prosecution. Two mitigating circumstances present: A. Voluntarily surrendered. B. Voluntary confessed his guilt. If both are present, considered as two independent mitigating circumstances, mitigate penalty to be a greater extent. Requisites of voluntary surrender: offender not actually arrested. Offender surrendered to a person in authority or the latter's agent. Number 3, surrender was voluntary. Surrender must be spontaneous, shows his interest to surrender unconditionally to the authorities. The law does not require that the accused surrender prior to the order of arrest. That matters if is the spontaneous surrender of the accused upon learning that a warrant of arrest had been issued against him, and that voluntary surrender must be by reason of commission of the crime such which defendant is charged in obedience to the order arrest is issued against him. Requisites for plea of guilty. Number 1, offender spontaneously confessed his guilt. Number 2, confession of guilt was made in an open court, competent court. Number 3, confession of guilt was made prior to the presentation of evidence for the prosecution. 8, that the offender is deaf and dumb, blind, or otherwise suffering from some physical defects which thus restricts his means of action, defense, or communication with his fellow beings. Basis 1, suffering from one physical defect which restricts him does not have complete freedom of action, and therefore there is a diminution of that element of voluntariness. The physical defects of the offender should restrict his means of action, defense, or communication with fellow beings. This been extended to cover cripples, armless people, even stutterers. Number 9, such illness of the offender as would diminish the exercise of the willpower of the offender without depriving him the consciousness of his act. Requisites feeble-mindedness of the accused, who in a fit of jealousy stabbed his wife, then carried her up to the house, laid her on the floor, and then lay down beside her. Warrants of finding in his favor of these mitigating circumstances. Number 10, and any other circumstance of a similar nature and analogous to those above mentioned. Example of any other circumstance. Number 1, defendant who is 60 years with failing eyesight is similar to a case of one over 70 years old. Number 2, outrage, feeling of owner of animal taken for ransom is analogous to vindication of grave offense. Number 3, impulse of jealous feeling similar to passion and obfuscation. Number 4, voluntary restitution of property similar to voluntary surrender. Number 5, extremely poverty similar to incomplete justification based on state of necessity. Number 6, spread the corpse is similar to passion or obfuscation, the act of the offender of leading the law enforcers to the place where he buried the instrument of the crime was then considered as equivalent to voluntary surrender. Stealing by a person who is driven to do so out of extreme poverty is considered as analogous to incomplete state of necessity. Except where the offender became impoverished because of his life. If his lifestyle is one of having so many vices, as a result of which he became poor. Circumstances which neither exempting nor mitigating. Number 1, mistake in the blow. Number 2, mistake in the identity of the victim. Number 3, entrapment of the accused. Number 4, accused is over 18 years old. Number 5, performance of righteous action. Let's go to Chapter 4, circumstances which aggravate criminal liability. Article 14, aggravating circumstances. The following are aggravating circumstances. Number 1, that the advantage to be taken by the offender of his public position. Number 2, that the crime be committed in contempt with insult to the public authorities. Number 3, that the act be committed with insult or in disregard of respect of due to the offended party on account of his rank, age, or sex, or that he is committed in the dwelling of the offended party if the latter has not given provocation. Okay, that's all for our activity 8E. Okay, thank you so much, sir.